you.
Good evening, ladies and gentlemen. Welcome to the Board of Appeals meeting for Tuesday, August the 25th, 2026. Prior to the start of this hearing, I wish to tell all in attendance the following. The Board of Appeals is a quasi-judicial board appointed by the county commissioners. The board is charged with the responsibility of applying the Charles County ordinance to each application for a variance or special exception in a fair and impartial manner after a hearing where all parties or interested persons are heard. Our decisions are not made based on the number of witnesses or the quantity of evidence, but rather on the quality of the evidence. So repeating a point of view or an opinion already given does not make it any more credible, and repetition is to be avoided. We request that proper decorum be observed and not speak until recognized. This evening we are operating in a virtual format. Each member of the Board of Appeals is required by law to be and remain impartial, can only base its decisions on the evidence presented at the hearing. Consequently, any verbal communication with a board member outside of the hearing room and pertaining to any pending case is strictly prohibited under the ethics of all independent boards. The board appreciates your anticipated respect for the process. I remind everyone here to mute your microphone until you are scheduled to speak to prevent background noise and interference. At this time, we'll afford any opportunity for any comments not related to the case being presented tonight. Madam Clerk, are there any? Seeing none. If there are no comments, then we'll move forward with the first order of business. We have one case to consider this evening. It's docket number 1459, Rivers Edge reconsideration. We should have received both the county's request for reconsideration and the applicant's opposition to the request for reconsideration. Madam Clerk, please conduct and record the board roll call.
Certainly. Vice Chair Benjamin Watkins.
Present.
Jennifer Walker.
Present.
Damian Chusada. I see you, but I don't hear you.
Present.
There you are. Thank you so much. Timothy Trainer.
Present.
And Chairperson Bud Humbert.
Present as well. Thank you.
That completes that role.
Our next order of business is to accept the agenda for this evening. I'll take a motion to accept the agenda as is.
Mr. Chairman, I'll move to accept the agenda.
Thank you. And a second?
I'll second.
The motion to accept the agenda for today, August the 25th, 2026, with no changes offered. At this point, Madam Clerk, would you do a roll call vote again?
Certainly. That acceptance was made by Timothy Trainer and seconded by Jennifer Walker. So we'll move to Vice Chair Benjamin Watkins. Accept
Approved.
the agenda? Yes. Damian Chusada
Yes.
and Chairperson Bud Humbert.
I agree. Moving on, we'll have the approval of the meeting minutes from the August 11th, 2026, the boarding house. We have the minutes. Take a motion to accept the minutes.
Mr. Chairman, move that the minutes for August 26th be approved.
And a second?
I'll second.
Thank you. Motion made by Mr. Watkins, seconded by Ms. Walker. All in favor signify by saying aye.
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 Are there any opposed? The motion carries unanimously. Thank you. Our case for this evening is a request by the county attorney's office to reconsider the Rivers Edge case, which, as you recall, was presented to this board between December of 2025 and April of 2026. Appealing the zoning officer's determination dated February the 8th of 2023 for a non-conforming use that had ceased for more than 1 year, and pursuant to the zoning regulations, the non-conforming use was considered abandoned. The board ruled in favor of Rivers Edge, reversing the zoning officer's determination, and the DNO was thereto adopted on July 14th of 2026. You have received the request for reconsideration, as well as the opposition to the request to reconsider River's Edge. Our charge this evening is to determine if we will reconsider the approval of the administrative appeal. I'll take a motion regarding the reconsideration of River's Edge.
Mr. Chairman, I'll move to reconsider docket 1459, River's Edge.
And a second? So we have a motion made by Mr. Trainer and seconded by Mr. Trisada. Madam Clerk, I'll ask for a roll call vote.
Mr. Chairman, let me just interrupt you for a moment. I want to make sure
Yes, please do.
everybody is clear what we're doing here. The county attorney, Mr. Potter, has filed a motion for reconsideration of the board's decision, and Mr. Schaller, if I'm pronouncing your name correctly, filed an opposition. And the hearing today is really whether or not you're going to grant the county's reconsideration, and then have a hearing at some later time on his reconsideration. And so the only issue today is the reconsideration itself. Are you going to agree that a reconsideration is appropriate and vote accordingly, or are you going to agree with Mr. Schaller that reconsideration is not appropriate and the original decision and order is appropriate? So that's what you're voting on today. And then what I would suggest is, since Mr. Schaller is here, I don't think Mr. Potter is here. Is that correct, Ms. Curtin?
He is here. He is here.
He's here.
Both are here.
All right. I mean, if you wanted just to have a full record, they have filed pleadings, but I would suggest that Mr. Potter give a brief statement of the basis of his reconsideration, and Mr. Schaller then give a brief response to that, and then I will give my comments on their pleadings and their argument, and the board can then make a motion to either grant the reconsideration or deny it.
Well, then we could just go ahead and take the motion that's on the floor at this point and put it on hold?
Yes.
Or does it have to be withdrawn? We'll just put that on hold and allow them to speak on it.
Let's hear from the parties first.
That would be just fine. So, Mr. Schaller, would you like to, would you like
Mr.
to
Potter. Mr. Potter should go
Mr.
first
Potter,
if he
Mr.
wants to
Potter,
argue.
please.
Okay. Thank you, Mr. Chair. And thank you, Attorney Brown, for setting the stage for the county's position as to the motion to reconsider. And I promise I will keep it brief. My motion to reconsider the decision and order was specifically as to the conclusion arrived at by the order. The order itself actually came to the conclusion that the River's Edge use had indeed been abandoned due to cessation of the use for excess of 12 months. The order then indicated that the county would not be allowed to or would not be permitted to breathe new life into said use. Board of Appeals, this body here, enjoys all the powers of the zoning officer, which the board found could not breathe new life into said use, but effectively did exactly that by saying that the use could continue from 12 months after the signing of the order itself. So it is the county's position that if the zoning officer would not be permitted to breathe new life into said use, then the Board of Appeals would not have the authority to essentially start the clock as of the date of the signing of the order. And the only determination that this board would have been able to make is an affirmation that the use had been abandoned and cannot be revived. That is my brief summation of the county's motion.
Thank you, Mr. Potter. Mr. Schaller?
Good
We're not
evening,
here.
Mr. Yeah, there we go. Good evening, Mr. Chairman, board members. I appreciate Mr. Potter's comments, brief, consistent with the county's motion. Needless to say, Mr. Holmes and Rivers Edge disagree in a few respects, and I think it's important for this board to understand where we are. This board actually said, under the strict application of the cold, sterile hand of the law, we would determine that the applicant's nonconforming use had been abandoned. The board declines to exercise such an application. That's in essence where Mr. Potter is by saying you're breathing new life into it. But what I think is important for this board to understand, and as Mr. Potter correctly pointed out, you step into the shoes of the zoning officer. And the zoning officer's authority is under 297-414. And number 6, the zoning officer gets to make the interpretations and determinations on the code itself. This board has its authority derived from the land use article, section 4306F, which gives you the right to reverse the order, wholly or partly affirm the order, modify the order, or issue a new order or decision. And then under the county code itself, 297-417E is in Edward, and this is important. This board may reverse, affirm, or modify the order and make any order, requirement, decision, or determination that, in its opinion, ought to be made. I want to say that again. Ought to be made in the case before it. So it's important to understand that I believe this board was rendering an opinion that ought to be made based upon, unfortunately, the convoluted facts that were presented to this board between the state, FEMA, and the county process. And attached to our opposition certainly is from the board's main minutes. I think from a practical point of view, we realize getting something out of the county, no fault to the county itself, just the way the system is set up for a commercial building over the water in 12 months is nearly impossible. You also had the guidance from the County Office of Law out that provided some insight, and you also had case law presented by my former colleague, Zach Gilreath, that identified you can't have an abandonment without an intention. So for all of those reasons, we contend that the board did render the proper decision before it, and thus this board should affirm its July 20th decision. And we would rest on our written pleading from that point on.
Thank you. Thank you. Council Brown.
Yes, Mr. Chairman. I provided some background to the board from a legal standpoint in my review of the county's position and the appellant's position as well. And I'm just going to summarize exactly how I see the case in terms of this motion for reconsideration. First, a threshold matter. In order for a motion for reconsideration to be considered by the board, it must be filed within 15 days after the mailing of the decision. In this particular case, no member of the board requested a reconsideration. Here, Mr. Potter, through the county attorney's office, filed a motion for reconsideration within 15 days. Technically, it is timely. However, with regards to the rules of procedure, Mr. Potter is required, and I'll just read it, Article XXV 297-414 as well of the zoning ordinance. The party filing such a reconsideration motion shall transmit copies to all parties to the proceedings and shall file an affidavit of mailing with the zoning officer, neither of which were done by Mr. Potter. There were probably 8 to 10 other parties in this case, members of the community, that should have received notice of his motion for reconsideration. They did not find it. They are not here today to argue in opposition or in support of it. An affidavit was not filed with the zoning officer. However, in spite of that defect, I would suggest to the board that you overlook the procedural defect and consider the case on the merits. The other issue is vote required. The zoning ordinance and the rules of procedure require that 3 members of the board of quorum must vote for the reconsideration or to deny it. And so when you take a vote later today, you need 3 members to confirm the motion. Then the standard for reconsideration, and that's Rule of Procedure XV3II. Revisory power of the board governs. Reconsideration only lies upon a showing of a mistake of fact or law. In this particular case, Mr. Potter's motion accurately cites a mistake of law. His mistake of law is that the board reversed the zoning hearing officer on the mistaken belief that the use, non-conforming use, had continued based upon the intent of the applicant. That's a mistake of law. The board, of course, in its order, sort of disagreed with that. Next, the issue that was raised by Mr. Schaller in his opposition, the standing of the zoning officer in the county to file an appeal. He makes the argument that the county is not aggrieved and therefore it cannot file an appeal. The problem with that argument is this is not an appeal. State law does in fact say that only an aggrieved person may file an appeal from an administrative agency to the court. This is not an appeal. It's a request for reconsideration. There is no agreement requirement for motion for reconsideration of an agency's determination. So Mr. Potter here appropriately has, he was a party before the board, and therefore he can file a motion for reconsideration. And again, the reasons for that are the following, just so that the record is clear. Under the zoning ordinance 297-414A, the zoning officer, when he states that he's not a party in interest, the following belies that particular conclusion by Mr. Schaller. 1, the docket in the case identifies Charles County zoning officer as appellee. An appellee is a party by definition. Rule 2K of the Rules of Procedure expressly defines a party to include respondents in an administrative appeal. The zoning officer is such a respondent. Rule of Procedure XII. It places the zoning officer in the initial burden of presenting evidence and argument to justify the decision appealed from. Only a party can make argument and present evidence. Section 297-414A of the zoning ordinance uses the broad term, any party in interest, not the narrow aggrieved person as alleged by Mr. Schaller. Therefore, the board should give the language's plain meaning. The zoning officer was a party in interest. And 5th, the Maryland decisions relied on by Mr. Schaller all concern the standing of administrative body to appeal an adverse decision, which I stated earlier, and this is not an appeal of an adverse decision to the court. This is a reconsideration by the same tribunal that rendered the decision and therefore is not analogous to an appeal from an administrative agency to the court. Then the practical analysis, if you were to adopt Mr. Schaller's position, basically the county would never be in a position to be able to appeal to the court any decision rendered by this board or any other administrative agency if you were to conclude without specific facts that the county attorney has no authority to file an appeal, in this case, by analogy, Mr. Schaller's document, a reconsideration. That just is not practical. And so at the end of the day, I would conclude, and I would suggest that this board also conclude, that the motion is timely, it is based on a mistake of law, it's sufficient for reconsideration. And then lastly, there are 3 independent grounds, however, that Mr. Potter failed to address in his motion, all of which were cited in the order. And again, we're going back to Rule XV3I, the revisory power of the board, and the grounds for reconsideration. And basically, that particular section says the following. A motion that merely restates arguments considered and rejected at the original hearing does not satisfy the standard. It is a request to relitigate. Mr. Potter has not requested to relitigate. He's not requested to add additional evidence. But the county framed his argument as a mistake of law, specifically that the board improperly imported an intent element into zoning ordinance section 29746A, despite the ordinance mandatory shall be deemed abandoned language. That's a mistake of law. Therefore, I would suggest that you deny the motion on its merits, not on the procedural defect that Mr. Potter has in his particular pleading. And then the merits would be the following. And there are three independent grounds to deny it. Number one, equitable tolling under the National Waste Managers case, which was cited by, I believe, Mr. Schaller, and which was in the original order. A county attorney had ruled in this case or communicated to Mr. Holmes that his case had not been abandoned under the terms because he had intent to proceed. Although arguably that particular conclusion was inaccurate, from an equitable standpoint, it induced Mr. Holmes to proceed with attempting to try to get approval. So equitable tolling was not denied by Mr. Potter in his motion, and that's an independent ground to confirm your original order. Second, detrimental reliance on the county attorney's written advice. Clearly, Mr. Holmes relied on the advice of the county attorney, and it would be a poor argument for the county attorney to tell Mr. Holmes 5, 6, 7, 8, 9 years ago that you have not abandoned, the law doesn't apply to you because you have an intent to reconstruct the structure, and then the same county attorney come in here today and say the deadline passed, you had no intent. And so Mr. Holmes detrimentally relied on the county attorney's written advice, and the order very clearly states that is one of the bases of the denial or overturning of the zoning officer's decision. And then the last basis, again, that Mr. Potter failed to recognize in the original order under section 29746A of the zoning ordinance in the Mark Lounge case, he makes the argument that that particular case, which dealt with a rebuild provision with a 1-year building permit trigger in a case involving no municipal delay and no advice of counsel estoppel. Therefore, that case is not even applicable here. That was not a non-conforming use or the type of case that we have here today. Therefore, my recommended disposition to this board, and of course it's up to you to make this particular decision based upon the pleading filed by Mr. Potter and filed by Mr. Schaller, but I would suggest the following: that you find that the zoning officer has standing under zoning ordinance 297-414 as a party in interest to file the motion for reconsideration. That you find the motion is timely and satisfies the rules of procedure of a filing standard of the motion asserting a mistake of law. That you deny the motion for reconsideration on the merits, on the grounds set forth in what I would suggest you do at the end of this case is make a motion to have me prepare for your approval an amended order and decision clarifying why you denied this particular motion for reconsideration. And as I stated earlier, any vote you do make today requires an affirmative vote of 3 members. And so those would be my comments on this particular case. And so you're now in a posture where you can make the appropriate motion.
Thank you, Mr. Brown.
Yeah.
Well, then at this point, if we're to follow our legal counsel's suggestions, then I'll go back to the maker of the motion that's still on the floor, Mr. Trainer. Would you like to withdraw your motion?
Sure, I'll withdraw my motion.
And the seconder, Mr. Shasada, would you withdraw your motion?
Yeah, I'll withdraw the second.
Okay, so at this point, we have no motions on the floor, and I'll accept another motion.
Okay, I do have a question, Mr. Brown. So, do we need to rule on kind of the two separate things? I see the issue of standing, and then the issue of whether we do the reconsideration. Are those two separate issues we need to to address?
No, I think we should vote on a global motion. Do you deny the motion for reconsideration? And if your answer to that is affirmative, you deny the motion for reconsideration, and that you would then instruct me to prepare a decision in order explaining why you denied the motion for reconsideration.
In that case, Mr. Chairman, I would like to move to reconsider.
So I have a motion on the floor. Do I have a second for the motion to reconsider, which would go pretty much against our legal counsel again, that and not withdraw? Seeing no second, then the motion dies for lack of a second. At this point, is there another motion to come to the floor? Mr. Brown, would you restate what we should be doing at this point? And we should be denying a motion to reconsider, which was made by Mr. Potter, correct?
Yes, my suggestion would be based upon the pleading filed by Mr. Potter and the pleading filed by Mr. Schaller and the order that you approved a month or so ago, that you deny Mr. Potter's motion for reconsideration. Stop.
Is anybody willing to do that?
So you're saying we have to basically reaffirm what was affirmed by this board already?
No. All we have to do is either we agree with Mr. Potter that we're going to reconsider our decision, or we disagree with Mr. Potter that we're going to reconsider our decision. It is my suggestion, based upon the pleadings and the argument, that you vote to deny his motion for reconsideration.
Even though the motion that just died.
Well, Mr. Trainor's motion was to grant Mr. Potter's request for reconsideration, to reconsider your decision.
Right. But the fact that nobody seconded, isn't that de facto saying we have to
but you still need an affirmative vote of three persons
because we have to
say that you deny Mr. Potter's motion for reconsideration.
Okay. All right then. Okay. Well, I move that the county's motion for reconsideration be denied.
And a second. We have a second by Ms. Walker. Motion made by Mr. Quesada and a second by Ms. Walker. Now the floor is open for discussion.
Just a moment,
and I'll go back to the maker of the motion.
Chairperson, was that Ms. Walker or was that Mr. Watkins?
No, Mr.
That seconded that.
Walker made the second.
She was muted.
Oh, she was muted. Okay, thank you. I didn't hear it. Okay, thank you so much. So just to confirm before we move forward, Mr. Quesada has made the motion and Mrs. Walker has seconded it.
Correct.
I'm clear. Thank you so much.
Sorry, I second. I apologize.
Thank you.
Okay. Mr. Quesada, as the maker of the motion, would you like to speak?
Yeah. So, based on the background and information provided by Mr. Brown, I was inclined that, to agree that the county had standing, but upon reviewing his interpretation of previous case law, in that it seems like then the county initially encouraged the continuation, and that, there is intent. That didn't seem as clear before, but it seems like now with the reading of the case law that there was some intent on the Mr. Holmes's part to continue that I guess kind of went against the idea that there was intentional abandonment. And so if I'm reading that correctly, as I looked over that, what you sent earlier, Mr. Brown, that if there was that intent was abandonment requires intent, correct?
No, not necessarily. I mean, although Mr. Holmes's counsel or prior counsel made the argument that he had an intent not to abandon the property, that was not necessarily accurate. However, your order rests on 3 additional alternative bases, and that is equitable tolling, detrimental reliance, and the intent is distinguished because in this particular case, even if you ignore whether or not he had intent, just on the equitable basis alone, you could grant the approval, which is what you did in the original order. So we don't need to give a total rationale at this particular moment because we've already drafted an order. We're going to stand on the 4 corners of the order, and then if your motion passes, I will draft a document that reaffirms that order and what you heard today from Mr. Potter and from Mr. Schaller.
Right. Okay. But it's relying on that case law as precedent for this case.
Okay. And Mr. Walker, you were a seconder. Would you like to speak? Mr. Walker, you're muted.
I agree with what Mr. Trusada said and Council Brown, and stand on the merits of what we made a decision, and we're gonna, let's move forward and let's help maybe this person try to restart his restaurant.
Okay. Anybody else would like to speak?
I would like to speak for a few minutes, if I may, Mr. Chairman.
Of course, Mr. Trainer.
Thank you. I believe we should reconsider the decision we made because we made a terrible mistake. We made 2 mistakes, in fact. The first was in ignoring the law, which prevents a continued non-conforming use when it's been abandoned for more than a year. As the board, we're given a lot of discretion on a lot of issues, but we're not given any discretion on that one. And for us to, out of our own sense of justice or righteousness, ignore the laws that our elected representatives pass is, I'm sorry, it feels to me like theft of democracy. These folks have been elected to make decisions. We've been elected to apply them to specific cases, and we've been appointed. We haven't been elected. So I think we made a terrible mistake in extending the ability to hold the non-conforming use for more than a year simply on what some county employee interpreted as Mr. Holmes' intention. The second part of it, though, is that this wasn't just 1 year. If you want to disagree with me, if you want to embrace the concept of equitable tolling or detrimental reliance, which really in this case is the same thing, that Mr. Holmes apparently relied on the absolutely erroneous interpretation by the county attorney's office, who imported a non-existing intention provision into the law. Then we basically incorporated that provision ourselves. Again, something we don't have authority to do. But this isn't just a 1 year issue. They were out of pocket for 8 years, and they continue to have no functioning restaurant, as far as I know. And we could see from the last year of correspondence between Mr. Holmes and the county that the issue wasn't some delay on the part of the state. The issue was Mr. Holmes' recalcitrance in complying with the county's reasonable requirements, specifically the requirement to submit a budget, which has been an existing requirement for at least 6 of the 8 years. So we have an egregious offender who we're letting off the hook. I think it's a mistake, and I think we should take advantage of this opportunity to reconsider our mistake and avoid the terrible consequences of having other non-conforming uses come to us based on similar sorts of mistaken interpretations of the law by county employees. Leads the county to vulnerability, and more importantly, it leaves the county's laws vulnerable. So I will vote no on Mr. Trasada's motion.
Thank you, Mr. Trainer. Mr. Watkins, would you like to say anything?
No, I guess I do want to say something, but I heard what Mr. Trainer said, and I understand that, but I'm still kind of not. I guess I don't buy this mistake of law argument. We had hearings. I'm sort of surprised that if this was the county's position, that none of that came through as part of the discussion when we had the public session. So that makes me a little concerned. So that's just my opinion. You can move on from there.
As you're welcome, Mr. Watkins. I'd like to make a note for the record before we move into a vote here. And what I'd like to do is, after observing and going back through and observing, what we did on like May the 12th at the work session concerning the permit timing, I made a policy remark and a prejudgment on this case, which I should not have done at that time. And I'd like to, just let everyone know that, that I was out of time. I shouldn't have done that when I came up with the permit timing as a policy remark. Okay. So at this point, assuming we're ready to vote, then Madam Clerk, would you please, if you could, reread the motion and take a roll call vote.
So we have a motion on the floor from Mr. Trasada and seconded by Ms. Walker to deny the motion for reconsideration. Are we ready to take a vote?
We are.
Okay. Mr. Vice Chair Benjamin Watkins.
I agree with the motion.
The motion seconded by Jennifer Walker. Again, your vote.
I agree.
The motion made by Mr. Trasada. Again, your vote. You're muted, sir.
You're muted, Mr. Trasada.
Yes.
Thank you so much. And Mr. Trainer.
No.
Thank you, Mr. Trainer. And finally, our chairperson, Bud Humbert.
I agree with the motion.
That means we have four people in agreement with the motion and one not in agreement. The motion passes that it will be the denial of the motion for reconsideration.
Thank you very much.
And I will prepare an order for your review and approval, memorializing the basis for your decision today.
Okay. Thank you for that. Then at this point, Madam Clerk, then we're looking for any additional business to come before the board to consider this evening.
We don't have anything else this evening to consider.
So,
excuse me.
Can you let us? We have our next meeting is going to be on.
So our next
October the 3rd.
October, yes. We have upcoming on the 13th. We will see Falcon Ridge on the 13th.
On the 13th. Okay.
Yes, of October.
Of October.
As it stands right now, we don't have anything in September. We had initially had a meeting scheduled to discuss our board's rules and procedures, which we have taken off the books. So right now, we have nothing in September.
Ms. Jordan, has an attorney been assigned from the county attorney's office to go over the procedures?
I'll let our zoning administrator speak to that. Reed?
Thank you, Mr. Chair. Thank you, Lisa. At this time, we haven't had an attorney signed to the board to review those documents. We're working with the county attorney's office, and as soon as they have an attorney signed, we'll be able to move on that. They're hiring new attorneys as we speak. Elizabeth Theobald is now taking on a judgeship over in Charles County. So,
Mr. Trainer, as a chairman,
congratulations.
in reviewing all the different suggestions and changes we had for our procedures, I sent it back to the county, to the attorney's office, and asking them to review everything before it came back to us.
Mm-hmm. I understand.
Okay. Then we will have October the 13th. And will that be an in-person meeting?
It will be. We wanted to make sure that the Falcon Ridge community had an opportunity to come into the building and be heard. So we will be meeting in the Blue Room.
And I'll
Excuse
be
me,
out
guys,
that,
my sinuses.
I'll be out of town that one. Okay.
Mm-hmm. Yep.
Okay. Then any other business?
Nothing else.
Then I'll take a motion to adjourn.
Mr. Chairman, I move we adjourn.
I'll second.
Mr. Trainer, we have a motion made by Mr. Trainer, seconded by Ms. Walker for adjournment. All in favor, aye.
Aye.
Those opposed, same sign. Motion carries. Thank you all very much for your time this evening.